Thank you everybody for attending. So we've got Laura and Anna joining us today from Anthony Collins, and they're going to be talking about future-proofing your care service. Just give you a little bit of outline around Delphi Care. So we're a care solutions company. We support health and social care providers nationally as well as children's services. There is going to be a section at the end which Kay is going to moderate for any Q&A. So if you want to ask any questions throughout, we'll feed that back and obviously answer that appropriately. I'm just going to hand over to Anna now, who's going to talk about the Employment Rights Bill. Thanks, Anna.
No problem. Good afternoon, everyone. I am Anna de Beck, as Sarah has said. I work at Anthony Collins Solicitors. We are a specialist health and social care firm supporting providers across loads of different disciplines, but my personal area of expertise is employment. And I have been asked to do a little intro on Employment Rights Bill, and I think we'll then take some questions. And in summary, the Employment Rights Bill comprises of nearly 300 pages, and there are about 35 different new measures that it introduces. So clearly we're not going to have the time to go through them all today. So I thought I would just focus on some key ones that I think will impact care sector more significantly, and also are ones that you can start preparing or thinking about. So number one, statutory sick pay, which will change from April 2026. So effectively, the bill introduces changes to statutory sick pay. Statutory sick pay will become payable from day one, and those on earnings below lower earnings limit who currently don't qualify for SSP will qualify for SSP going forward and will be entitled to receive 80% of their usual earnings. This therefore will have significant impact on your payroll costs, and I think also may lead to increased short-term absences or a higher level of short-term absences. So in light of this change, I guess three things that I would recommend you think about. The first one is probably an obvious one, but assess financial impact and budget accordingly. The second one is strengthen your absence tracking and train managers on effective management of sickness absence. And the third one is consider greater focus on workplace health initiatives to effectively reduce sickness absence rates. So that's sickness absence. The second key area for social care providers, I think, will be the introduction of the Fair Work Agency. Again, this is one that is likely to come in, or we know now will come in April 2026. And effectively, the bill introduces this agency, which is a completely new state enforcement body with powers over a number of areas. So holiday pay, statutory sick pay, minimum wage enforcement, employment agency rule enforcement. And therefore we will see a significant shift from the current system where employees, workers effectively must enforce their rights individually, apart from national minimum wage, which is enforced by HMRC, to a system where effectively the Fair Work Agency will proactively ensure and monitor compliance. So you are likely from April 2026 to face inspections, audits, and penalties for non-compliance. So again, just thinking about what you can do, again, probably three areas that I would suggest you focus on. Review compliance with holiday payroll, statutory sick pay, and national minimum wage, and ensure that you keep records in place, appropriate records in place. The second one is track your holiday pay entitlements going forward and ensure that any historic liabilities are settled so you don't have back pay claims. And then the third one is introduce systems that enable you to provide appropriate information to the agency in the future should it come and inspect. The third area is the introduction of rules around sexual harassment. So very briefly, in October 2024, we've had a new duty introduced, which requires employers to take reasonable steps to prevent sexual harassment. Under the bill from October 2026, so in about a year's time, that duty to prevent sexual harassment will change so that you have to take all reasonable steps to prevent sexual harassment. Now, my experience is that there is a lot of providers that even now haven't introduced changes post October 2024. I think the key steps, again, 3 key things: review and strengthen your anti-harassment policies, conduct risk assessment and deliver training, and then develop implementation and monitoring plans to ensure that you are appropriately addressing this duty. The fourth area that I want to mention is adult social care negotiating body. I'm sure you have heard a lot about it. Effectively, as you all know, currently there is no uniformity of pay across adult adult social care sector. Effectively, the bill introduces a new power for the government to establish a sector-wide negotiating body, i.e. this adult social care negotiating body, and the government has now confirmed that this body will be established in October 2026. Effectively, the body will consist of employer representative and trade unions representing workers in the sector, and its job will be to agree terms and conditions for workers across the sector. That's likely to include care workers, senior care workers, but also there's some suggestion that it will include more senior staff. And in essence, once agreed with the negotiating body and approved by the Secretary of State, employers will be bound by whatever terms and conditions are agreed. So effectively a bit of a model similar to NHS model. We don't know what that will look like, but my key two areas probably would be stay informed on developments and also try to assess potential cost implications, because there is no doubt that under those new arrangements, pay will increase quite significantly above the national minimum wage level. And then just very briefly, 2 other areas, but they're not coming in until 2027. The first one is day 1 right to bring unfair dismissal. So effectively at the moment, there's within the first 2 years, employees cannot claim if they are dismissed an unfair dismissal. Going forward, they will be able to do so from day 1. So I think key things to do over the next 2 years is strengthen your hiring and onboarding processes, and then I think introduce structured and documented probationary review process. And then the last one, again from 2027, there will be changes to 0-hour contracts. As you know, Labour government initially promised a complete ban on zero-hour contracts. I think luckily for the sector that is not being implemented, but they are introducing from 2027 a duty to offer guaranteed hours to qualifying workers, a requirement for reasonable notice of shifts for 0 hours and agency workers, and compensation for last-minute cancellation and shift changes. So again, in terms of recommended actions, I would say build system to track your 0-hour workers, so you know exactly what hours they are working. Review your agreements with agencies so that you are not liable in case of future cancellation or shift changes, and then consider entering into collective agreements with the workers that enable you to vary the requirements under the bill. But as I say, not until 2027, but I think it should be on your radar, and you should be thinking about that. There you go, Sarah. I think that was 10 minutes as promised.
Anna, I had quite a few questions lined up from providers that I've met in the past couple of weeks, and to be honest, I think you've answered most of them already because it was extremely informative for 10 minutes. I think one question that would be good for providers is, do we think that the bill's going to affect probationary periods and notice requirements in regards to adult social care?
Yeah, so I think definitely in terms of probationary periods, at the moment most providers have 6 months, and the government has suggested, I mean, the first impact will be that because day one right to unfair dismissal will be introduced, it won't be as easy and simple and without consequences to dismiss people within those first 6 months. What the government have promised or indicated is that there will be a modified procedure. So at the moment, within the first 2 years, you can do whatever you want. After 2 years, there is ACAS code of practice that requires a certain way of dismissing. What the government has said is that there will be a simplified dismissal process within the first 9 months, which means that effectively probationary periods will probably need to be looked at as first 9-month periods, but also the process for dismissing the employees in that 9-month period will have to follow the guidance that we expect the government will produce before the implementation date of 2027.
No, thank you for that. Do you think from your experience that could be more costly for providers than the dismissal process?
I think undoubtedly everything that's being introduced under the Employment Rights Bill will be more costly. I think from an administrative point of view, effectively, there is a lot of new processes and systems being introduced. And I think that will mean that particular HR resource or operational resource that manages those sort of employment related things like probationary periods, like holiday pay, like sick pay, like 0-hour contract arrangements will need to be expanded, and therefore there will be probably additional roles that people will need to recruit or additional systems that providers will need to introduce that will unfortunately cost money.
Absolutely, but if they don't invest in those HR processes, it's going to have long-term problems, isn't it? And it's going to take registered managers or operational teams off the ground.
Absolutely, yeah. I think the positive about the Employment Rights Bill, if I can really quickly, is that I think it will introduce these new requirements, systems and procedures, and I think providers can use those to their advantage to try to support recruitment, positive recruitment and positive retention.
Oh, brilliant. So hopefully it'll develop more positive cultures in care.
Yes.
Amazing. Lovely. Thank you, Anna. We ran over, didn't we now? We've gone to 15 minutes. So we'll hand over to Laura, who's going to talk to us about challenging fee uplifts, recovery and liability. Thank you, Laura.
Oh, thank you, Sarah. Hi everyone. I'm Laura Jordan. I'm a partner in our social care team at Anthony Collins, specialising in corporate and commercial work. I've been advising social care providers, probably about 17 years. I don't look that old, do I, Sarah? But yeah, no, I have for a long time, and 8 of those years was spent as legal director of a nationwide care provider. I was actually a client of Anthony Collins, and I was Anna's client actually. I liked them so much that I decided to join them in November 2023. We've done a number of transactions, mergers, acquisitions, and disposals in that time, over the last sort of 16, 17 months. But yeah, we seem to be in a position in the sector really where we're obviously, as we've been talking about, facing kind of mounting financial pressures. And I do speak to a lot of my clients about funding shortfalls and how to challenge fee uplifts. And really off the back of the Stoke case, where we Anthony Collins advised a number of charities who were challenging the 1.4% fee uplift that Stoke offered, which is really derisory. And we were successful in that case where the High Court deemed that what Stoke had offered was actually unlawful and failed to account for the cost of care. I don't know if you're seeing that, Sarah, but there's lots of low care.
I was muted then. Sorry. No,
It's all right.
100%. 1.4 is just an insult to the sector.
Yeah, and really, I think it's having that confidence, isn't it, as a provider to challenge ICBs and local authorities when the fees uplifts or care placements. And you've got providers who've got lots of legacy placements which are really, really underfunded and go back a long time and don't actually marry up with the cost of care. And actually, having that confidence to challenge local authorities is important because they actually must consult. We know that lots of local authorities do consult, and I've been part of provider consultations, but actually not just consult, but go through the feedback before making decisions. And that's what Stoke didn't do in that case. Is they consulted, but they didn't take any notice of what the local providers in that area said. They've got to fulfill their duties under the Care Act, and there's lots of stuff. I know lots of sector bodies have got some really good wording on the Care Act, and we've certainly got it in our templates that people like Care England and the Home Care Association use, which you can include in your letters to local authorities.
How is the best way to challenge it, Laura, without causing that breakdown in relationships with the local authorities? I think that is what a lot from providers I've spoke to from the care associations, a lot of them are like, well, if we do that, they're not going to place with us anymore.
Yeah. Well,
and obviously that's alarming.
I know, but actually they kind of expect it now, and many providers have been challenging local authorities and ICBs for a number of years on legacy rates or underfunded placements. And if you've got the data, so if you use Care Cubed or something, and if you've got the data and you can show, look, the cost of care is X, and you're only paying me, like I had someone only paid £700 a week for £2,000 worth of care, if you can show that, and I think a lot of local authorities you can't argue with that, can you? And they have to take account to the rising cost of care. And I know, and you don't want to, there's a tricky tension, isn't there, in terms of challenging commissioners. In some cases they expect it. I'm sure Stoke did when they were offering 1.4%, but there's a way of doing it so perhaps your operational colleagues don't do it, but you have your commercial director, or it's about, I know some providers, you play a kind of good cop, bad cop role with it. You get head office challenging and people, registered managers, focusing more on operational delivery. But if you haven't got that, and if you can't do that, I think challenging in a sensible way where you can actually show the data and show the lack of funding, and actually show that. I think local authorities have got to ensure, as have ICBs, that decisions regarding fee increases are not discriminatory, and that was really clear in the Stoke judgment, and consider the well-being of residents. And if for fee uplifts like 1-2%, that's discriminatory, isn't it? That's putting people's homes at risk. That isn't thinking about the best interests of the people supported, who deserve great quality care delivered by consistent staff teams. So The other way that I encourage providers is advocacy. I don't know if you've seen this with advocates out there like Access Charity, who help also bring the voices of the people supported to the table. I think that's
it's
so
an independent
important.
person as well, isn't it? It's not just a provider going, actually, you need to pay us more money. It's actually, this is what the person's needs are. They potentially can't communicate themselves. So actually we are advocating for them on behalf of their placement and their home. And that care and support, it's 100% drive advocacy.
I've done
Definitely.
it. I've done it on fee negotiations. I think it's really powerful. I've even had people supported with capacity, where managers have helped them write emails saying, you know, I'm worried about the cost of my care. I love where I live. The outcomes I'm receiving here. I'm being assisted to live more independently. That's powerful stuff, isn't it? So,
Yeah.
I mean, for care providers, the state judgment and challenging, I know it's hard, but actually that judgment reinforces the right to challenge fee decisions based on as well public law principles. And I know that I speak to a lot of clients who struggle with ICB fee uplifts, and even getting someone from the ICB to respond. We have automated inboxes with our ICB commissioners, don't we? And actually they themselves have public law principles apply to the ICB as well as the local authority. So you should be challenging them if they're below, if their fee offers or placements are underfunded, in terms of, look, they've got a duty to act fairly, and their fees must reflect the reasonable cost of care. And you know, the courts, what we've seen, will hold local authorities accountable for decisions affecting sustainability. And I mean, I would always say, if you can start practically with letters from your CFO and letters from your CEO before getting lawyers involved, but doing sort of, we talked about that relationship, didn't we? So we can help write letters in the background, but at the start, it's about using the wording that you can get from. It's, I think, important to engage with sector bodies on this, because they can share sort of care act wording that you can put into your commissioner negotiation levels, just letters to start those conversations. And I really wouldn't initially say letters from law firms, because that's quite aggressive to start with. It's I didn't used to do that when
No, absolutely. And the thing is, if going back to what we were talking about, the people that actually draw on the care and support, if you can capture that and share that, obviously considering the Care Act and their rights, then actually you've got to think about morally and ethically at what point you've got to bring in people outside of the organisation without it impacting on how it looks on the ICBs and the local authority.
Oh yeah, no, 100%. I mean, the other thing I was going to mention, and I don't know if you've seen this, but improving financial management through this time, you know, challenging things like unpaid invoices. I had a client recently that had delivered care 3 years ago and had not been paid by the local authority for that. And they're like, oh, should we challenge? And actually, you should, and we are helping them do that, because the local authority, you know, has been unjustly enriched. The care's been delivered, but they haven't paid for it. And there's a limitation period there of 6 years. So it's difficult if the care was delivered 6, 7, 8 years ago to challenge. But certainly in the last 6 years, you should go back and go, Joe, I deliver this care, you owe me. And we've got some legal wording around that, and things like there's some nuggets in your contracts. And I always say, look at your invoice terms in your contracts and your payment terms and your interest rates for late payment. So for instance, in the ICB NHS contracts, they've actually only got 5 operational days to dispute an invoice. So if, you know, and I know sometimes our NHS are late payment and have paid invoice late. So under special conditions 36 20 spot 22, I used to quote this, they've got to pay, they've only got 5 days. So, and interest rates under the NHS standard terms and conditions for late payment of invoices is 8%. So it's just knowing things like that, isn't it?
And it's making people accountable for their own contracts as our operators. They are accountable for delivering that care. So actually, if people are accountable for placing it and paying for that care, then it's about actually showing them you're aware of those contracts, isn't it? And having the confidence to actually quote what they've agreed to.
Yeah, I think not just commissioners, but looking at through these times of financial pressures, looking at your looking at other contracts. So looking at your lease terms and whether you've got any onerous lease terms, or looking at, I had one recently with really onerous terms with an agency where every year they could just unilaterally apply a fee uplift to their fees without consent. So having a look at those and actually going, well, that's an unfair contract term. We should really, both parties should really agree before you uplift my agency fees. So it's just having an idea, isn't it? I think, and being more knowledgeable, not putting your head in the sand. I think sometimes we find that people do, and I get it. There's a real inclination to do that when things get tough, but I can really encourage you not to lean into sector bodies and other other contacts in the sector so you don't feel alone, because it can be a little bit of a lonely place, I think, sometimes. I don't know.
But, no, and I think it's difficult, Laura, isn't it? Because at the minute, health and social care, and has been for a long time now, is very strained. So people do a crisis purchase, not necessarily look at the terms of a contract. Yeah, we need it now, and then think about the impact on 6 and 12 months' time. So I think it's about actually stepping back, reviewing it before you sign into something, and actually that negotiation period, isn't it? And making sure that you're confident in what's expected for both parties.
Yeah, 100%. I wonder, just mindful of time, is it question and answer? Have we got
Oh, have we got any questions?
I haven't looked.
I've got a couple of questions, but also one thing I wanted to ask is, we know that a lot of providers struggle with this fee uplift piece, and I'm just wondering why more providers don't go through those early stage letter writing. Is it because they don't know what to do, and are there some resources to turn to for that early intervention before obviously they reach out to someone like yourself? Or
I think if you join associations, they do have a lot of templates where providers have successfully use a letter, a particular format, which will refer to different legislation, and they are available. And we have actually signposted a few providers to those templates and have used them. So I think it's just about being in the know, isn't it, Laura, and speaking to other people, other providers in similar services.
Yeah, I think those templates have got our word again.
Yeah, they are. Definitely refers to the Stoke case, 100%.
Yeah. It's why I think it's confidence as well, isn't it? And like we're talking about, Kay, not wanting to upset your customers, but I think there are tactical ways and strategic ways to do it to preserve your position whilst ensuring, because I think you're acting in the best interest of the people supported as well. If you are pushing back and saying, actually, you're not paying for the actual cost of care to this person, and we deliver great care, and these are all our amazing outcomes, and this is what it's going to cost. And I think it's so important to do it. It's just having that initial confidence to do it, but there is a lot of support and help out there, definitely.
Amazing.
Have
we got any?
Yeah, there was a question around the unfair dismissal piece, and Anna may want to join, although it might be a good one for you as well, Sarah. So the question was, so Anna mentioned around strengthening recruitment process, and the question was, how do we strengthen the recruitment process to ensure we meet what's coming? Any thoughts?
Do you want me to get that, Sarah?
Yeah, you can do, Anna.
Yeah.
And I'll just chip in.
I guess, from my experience of dealing with situations where things go wrong, is that sometimes the writing was on the wall. But I think, unfortunately, we live in an environment where there is a lot of competition for care workers. Recruiting care workers or people into the sector is very difficult, and I understand it, but I think providers often compromise. So we can get somebody in quickly, they're not ideal candidate, but we'll just get them through the door because we need somebody to fill the role. It's dangerous for many reasons, but as I say, I'm not judging. I understand why people do it, but I think in the future it will become even more dangerous. So I guess robust recruitment processes, making sure that you do conduct proper interviews, that you wait for proper references to come in. If there is something in the reference that, makes you feel some suspicious, pick up the phone to the previous provider and check it with them. Google people.
Yeah.
Social
You
media.
know, yeah, exactly.
We've all done
You
it.
know, actually, I think, you know, I've recently dealt with a case where within a month of care workers starting, we received a whistleblowing complaint because a colleague or somebody Googled the individual, and there was loads of very derogatory articles about that care worker online, but we just, or the client just didn't pick that app because, you know, the CV looked all right. They just wanted to get somebody in. So I think effectively do your due diligence properly on the people that you recruit.
And as
Yeah.
well, you know, to kind of second what you've said, Anna, Skills for Care launched value-based recruitment, and
Yeah.
literally it's the 5 A's. It talks about articulate, attract, apply. I can't remember the other two, but actually it's free to download, and it's a really good tool for providers, and it just tells you how to review that onboarding process and how you identify what good looks like, what good doesn't look like, where there's gaps in employment, how you rectify that, and how you risk manage it, and actually how you look at cultural beliefs, ethical beliefs, and how you capture that during that onboarding stage. And that's free resources that are available. And I think it's just about knowing how to coordinate and direct that, and embedding it into your services. It's literally, you could do that once a year and change your policies depending on what that recommends. And it's free. It's free, so that will help build a more positive culture.
It's a great tip.
Yeah.
We can share that as well, actually. Well, I will share that, okay.
Yeah, I was going to say after that we can share the letter template and the Skills for Care link. But I can't believe it, but we're already at 2:31.
We did it.
I talk too much. Knew this would happen.
I just wondered, has anybody got any last minute questions? I think we're looking good.
I think we're going to circulate this anyway, aren't we? With any tools that we've made reference to, and obviously contact details for Anthony Collins, for Anna and Laura, and obviously for ourselves. And obviously, thank you to Laura and Anna for hosting with us. It's been lovely having you. Really useful and informative.
Anytime.
Thank you for attending.
Take care. Bye.
Take care. Thank you. Bye bye.